Good afternoon, and welcome to the latest webinar from the Current Issues and Insolvency Legal Update from Shepherd and Wedderburn. Before I start the webinar, we have a few housekeeping points to run through. To keep background noise to a minimum, I have placed each of you on mute. You can, however, use the chat function throughout the presentation to post any questions that you might have, and I will endeavour to answer them at the end. Please include your email address when asking a question so that I can answer your query by email if there's not enough time once the webinar has finished. My name is Serena Weir and I'm a solicitor in the Finance and Insolvency Litigation team at Shepherd and Wedderburn. Today's webinar will focus on dealing with residential property in distressed situations throughout the UK. Firstly, I will consider the current landscape against which lenders and appointment holders seek to realise residential property for repayment of sums owed by a debtor. I will then go on to consider some of the practical steps which can be taken to make the realisation process run as smoothly as possible, and share with you the benefit of my practical experience about the steps which I have seen taken by debtors and their representatives to frustrate or delay that process, and what practical steps can be taken to manage that. It would be fair to say that the legislation concerning repossession of a residential property is heavily weighted in favour of the debtor. This is recognition of the fact that this process is a very drastic one and could result in the debtor and possibly the debtor's family being made homeless. Accordingly, Parliament has built in a number of protections so as to try and ensure that repossession of a residential property is a very last resort. Whilst the precise terms of the legislation affecting lenders and appointment holders throughout the UK is different, the aim is identical: ensuring that lenders and appointment holders act towards the debtor in a way which is fair and reasonable, and that repossession of residential property is a very last resort. Firstly, I would like to consider the position of a lender in Scotland. In circumstances where a debtor has granted a standard security over his property, and either the lender is fully secured or the debtor has no other substantive assets, it is likely that a lender will look to exercise their rights in terms of a standard security granted to them by the debtor. Unless the debtor is willing to voluntarily hand the property back to the lender, then the lender will need to be able to demonstrate that it has followed the pre-action protocols, demanded the debt, called up the standard security, and then present an application to the court for authority from the court to repossess the property and eject the debtor and his family. The most practical piece of advice that I can provide is a very simple and straightforward one. It's the importance of keeping a record of all correspondence with the debtor. This ties back to compliance with the pre-action protocols which I mentioned a moment ago. Broadly speaking, the pre-action protocols provide that a lender has to demonstrate that it has provided certain information to the debtor regarding the terms of the standard security, the amounts owed, and counselling them to seek advice about their position from agencies such as their local housing authority and citizens' advice. That correspondence between the lender and the debtor is narrated in the application to the court for authority to repossess the property and eject the debtor. And copies of this correspondence are also produced to the court as evidence of compliance with the pre-action protocols. In my experience, being able to present the court with copies of letters, emails, file entries of calls or telephone messages just makes it that much easier to convince a sheriff that it is fair and reasonable that decree be granted in favour of the lender. Keeping a record of correspondence can also be invaluable in circumstances where a debtor appears in person at court. As you can imagine, in these circumstances, a debtor can often be looked upon very sympathetically by a court. In such circumstances, debtors can often say that they have written to a lender with a proposal and are waiting to hear back from them, and seek to delay matters for that reason. It goes without saying that any proposal put forward by a customer should be responded to in writing, in plain, straightforward language, setting out the reasons why the proposal is not acceptable. The same proposition stands for repayment agreements which are reached between the lender and the debtor. So if we take the example where a debtor shows up to court complaining that he has made a proposal to the lender but has not yet received a response, being able to produce a copy of the letter to the debtor from the lender, setting out the fact that a response has been produced, allows the sheriff to effectively draw a line under that matter and prevent it from being an issue which delays matters further. I'm also seeing an increasing trend by debtors and their representatives to seek to challenge the lender's compliance with the pre-action protocols at every single stage of proceedings. Lenders required to comply with the pre-action protocols both before and after the calling up notices have been issued. The difficulty for lenders is that there are no hard and fast rules as to what will be considered fair and reasonable by a court. The practical advice that I can provide to lenders is to avoid delay in issuing correspondence to the debtor in order to comply with the pre-action protocols and to keep evidence of proof of having sent this. For example, on expiry of the 2-month period of notice after the calling up notices have been issued, lenders are still under an obligation to comply with the pre-action protocols. So, at the end of this period, if the debtor has failed to make payment of the sum demanded in the calling up notices, then lenders or their solicitors should not delay in issuing correspondence to the debtor, reminding them of the terms of the standard security, reminding them of the total sums which are outstanding, and counselling them to seek advice. It may be the case that steps have indeed been taken by the debtor during the 2-month period of notice, which means that a lender may not immediately be moving to enforcement of the standard security. For example, the debtor has begun marketing the property for sale or has made a complaint to the lender. In those circumstances, my advice is that a lender would still want to issue this correspondence in order to comply with the pre-action protocols just as soon as possible. That correspondence can of course be tweaked slightly so as to include reference to the ongoing circumstances in order to take these into account. For example, that the property is presently being marketed for sale. It may also be the case in Scotland that a trustee in sequestration looks to take steps to realise a debtor's residential property. Complications can arise if the property is owned jointly with another party, such as a spouse, or if a spouse or a civil partner or other dependent lives at the property, such that it falls within the definition of a family home. In such circumstances, and where the debtor and the relevant parties are not willing to consent to the sale of the property, the trustee in sequestration will need to do the court action for consent from the court to sell this property. Again, any such application can be made much more straightforward and less prone to challenge if the trustee can provide an up-to-date valuation, copies of and proof of delivery of important items of correspondence, such as initial letters notifying the debtor of your appointment, and any notices to non-entitled spouses in terms of Section 16 of the Bankruptcy Scotland Act 1985. Copies of your pre-action correspondence to the debtor, offering them an opportunity to propose some way to resolve matters other than by way of the sale of the property. And confirmation from the accountant in bankruptcy that they agree with your proposed course of action. Where their home is at risk, it is understandable that debtors and their partners will make every effort to try and frustrate or delay the process. The practical advice I would give is to ensure that if the property does have to be sold, ensure that this is communicated clearly, directly and early on to both the debtor and their partner. Correspondence should be sent to the debtor and their partner separately, and you should retain proof of having issued this correspondence. Where any face-to-face discussions are arranged, you should take steps to try and ensure that both parties understand the implications of what is being discussed. Again, clear and contemporaneous record keeping negates any suggestion at a future stage that they were not aware that the property had to be sold and that they need more time to make alternative arrangements. We've spoken about a lender enforcing a standard security over residential property in Scotland, and there is a very similar set of pre-action protocols which apply in England and Wales, and which lenders need to comply with before they can take steps to repossess a residential property. These pre-action protocols operate in a similar manner and are based on all of the same principles that I spoke about a moment ago, ensuring that a lender acts in a way which is fair and reasonable, and that repossession of a residential property is a very last resort. However, in England and Wales there is another remedy which is available to lenders which is unique, and that is the power to appoint an LPA receiver, which I will focus on for the rest of this webinar. The appointment of an LPA receiver is an option which is much used south of the border. It is a useful enforcement option for lenders who hold a security over land. An LPA receiver is a receiver appointed under a mortgage or charge. Where a mortgage is by deed, a power to appoint the receiver is implied by the Law of Property Act 1925, hence the name LPA receiver, but there may also be a purely contractual power of appointment in the mortgage itself. LPA receivers are also known as fixed charge or non-administrative receivers. An LPA receiver is not an insolvency practitioner, but is generally a surveyor, and it is common for two LPA receivers to be appointed because of the practical advantages of that in terms of availability for signing documents and taking decisions. The main purpose of appointing an LPA receiver is to take control and sell the mortgaged property so as to recover the debt. However, often that property is rather messy. For example, if there is a large buy-to-let portfolio with lack of clarity as to who is in occupation or on what basis. Therefore, the property may need to be put into better order before it can be sold, and vacant parts may need to be let. In the type of buy-to-let portfolio situation which I've mentioned, it may be important simply to take the management of the property and the rental income out of the hands of the defaulting borrower and into the hands of an LPA receiver. Appointing an LPA receiver in this type of situation relieves the lender from the burden of managing and then perhaps marketing the property if a sale is sought in due course. It should also avoid the lender becoming a mortgagee in possession, although in practice the lender may decide to remain involved, in which case there are risks attached to that, which I will discuss later. Another advantage for a lender is that its exposure to a claim by the borrower arising from the management and disposal of the property should be reduced. As I mentioned, the idea behind appointing a receiver is to recover the debt owed to the lender, and the receiver owes a primary duty to the lender to secure repayment of that secured debt. The receiver acts as agent of the borrower and also owes a duty to act in good faith on behalf of the borrower and must use his powers for proper purposes. Always bearing in mind his primary duty to the lender, a receiver must manage the property with due diligence. A receiver need not carry on the borrower's business, but if he does so, he has to take reasonable steps to try to do that profitably, and a paper trail is invaluable here. As regards the powers available to receivers, there are powers in the Law of Property Act 1925, but as these are inadequate, the mortgage document itself will generally extend them by express wording. One example of the inadequacy of the Law of Property Act is that it does not grant a receiver any power to sell the property. This is the reason why most appointments of receivers are made under the terms of the mortgage itself, rather than just relying on the Law of Property Act, because this allows those extra powers to be set out clearly. Setting out the scope of the powers clearly and comprehensively can assist in defeating any challenge by the borrower as to the lawfulness of the receiver's actions. By way of an example, the most important powers that the mortgage will typically grant to a receiver include the power to sell or otherwise dispose of the assets to which he is appointed, the power to take possession of those assets, powers to protect the assets, for example by insuring them or arranging repair, and a general power which is a catch-all type provision allowing the receiver to carry out any function necessary or conducive to getting in possession and preserving the assets within the scope of the receivership appointment. When a receiver is appointed, a strategy will be decided upon following the initial assessment of the property and the available options. If, for example, there are tenants in the property, the receiver's role may simply be limited to managing the property or collecting rental income. In other situations, for example, where the occupancy cannot be established or if the tenants have defaulted on the tenancy agreement, possession proceedings may be issued. If the tenant or occupier refuses to give vacant possession, the receiver may then go on to seek authority from the court to repossess the property and then exercise its power to sell the property with vacant possession. Borrowers have tried to challenge the appointment and actions of LPA receivers on many occasions, but the courts have generally been quite robust in clarifying that although the relationship between an LPA receiver and the borrower is that of agent and principal, in reality, the LPA receiver is obliged to protect the lender's interests as a matter of priority. So the LPA receiver really owes no greater duty to the borrower other than to ensure that he acts in good faith in his dealings. I mentioned earlier the risks attached to lender's involvement with an LPA receivership. There have been some cases where receiverships have been successfully challenged by borrowers, especially where the lender has interfered in the receivership or expressly directed its progress and strategy. There is a fine line to be drawn between interference and involvement. A practical tip that I would give, therefore, is that receivers and lenders should be alert to the risk and take care with the wording of communications to minimise the scope for them to be construed as undue interference or undue direction of the receivership. Another area of challenge arises from the need when selling a property to obtain the best price reasonably obtainable at the time of the sale. This is a fertile topic for litigation, and therefore it is important that receivers ensure that if they are seeking to sell a property, that they have a paper trail to demonstrate, if challenged, that there has been proper marketing, there has been a realistic sale price, and that professional valuation and sales advice has been taken. It is useful to note, however, that case law has clarified that provided there has been a proper marketing process, the fact that the sale price the receiver actually achieves is less than the market price of the property at the date of his decision to sell does not cause him to breach his duty to obtain the best price reasonably available. That concludes today's webinar. What I'm now going to do is take questions. As I mentioned at the outset, questions can be submitted by typing in the chat box, and whilst you're doing that, I would just like to take this opportunity to mention that there are also a number of other webinar series which are being run by Shepherd and Wedderburn at the moment. If you want to find out more about these, the link to your webpage is on screen now. A question which I'm often asked, particularly in context in Scotland, is in relation to what obligations might be imposed on a lender or an appointment holder who is selling a property or recovering rental from a tenant. And broadly speaking, in Scotland, when you're dealing with a residential property, if a lender or an appointment holder takes steps to take physical control of the property or collects rental from a tenant, then they will be considered to have stepped into the shoes of the owner or the landlord. And what that means is, whilst they get the benefit of a vacant property or a rental stream, they are also responsible for any statutory notices or environmental liabilities concerned with the property. In the latter case, that's to say where you are collecting rental from a tenant, they're also responsible for those obligations which would have rested with the landlord, for example, fixing a broken roof. Generally speaking, concern about environmental liabilities associated with a residential property will be remote, but should you have any concerns, it's always advisable to instruct a specialist report to flush these matters out. Again, in the situation where you are stepping into the shoes of a landlord, regard should also be had to the precise terms of any lease being adopted, particularly those provisions which will allow the tenant to be removed from the property. Finally, it's just a matter for me to thank you for tuning in to today's webinar. I hope that you'll join us again in the future, and thank you very much for your time and for your attention.